English land law is the law of real property in England and Wales. Because of its heavy historical and social significance, land is usually seen as the most important part of English property law. Ownership of land has its roots in the feudal system established by William the Conqueror of 1066, and with a gradually diminishing aristocratic presence, now sees a large number of owners playing in an active market for real estate. The modern land law sources derives from the old codes of common law and equity, along with legislation such as the Law of Property Act 1925, the Settled Land Act 1925, the Land Charges Act, the Trust of Land and Appointment of Trustees Act, and the Land Registration Act 2002. Land law impacts upon many facets of our day-to-day living. It determines the difference between what is property and what is land. Who owns property in the land? Who may have access to land? Your rights to land as a tenant, and how to utilize your land. Land law is unusual in that you can own it outright but still be limited in how you use it. Ultimately, land law is looking to determine what interests there are in the land and therefore what a person can do with their land. These interests can be impacted depending on whether the land is registered or not. Beyond owning an interest in the land, less obvious interest can come in the following forms. Number 1 is minor and overriding interest. Number 2 is equitable interest. Number 3 is covenants. Number 4, leases and licenses. Because we are only studying private rights in land, we define property as rights against the world, in contrast to the contractual rights, which are rights against individuals. Thus, when a child shouts mine, a landowner says keep out, or a corporation seeks an injunction alleging trademark infringement. All three claimants are asserting that they have rights better than anyone else in the world, or at least, for reasons you'll see later, better than the vast majority of the world, including the individuals to whom these actions are directed. In other words, a private property right gives the rights holder the ability to exclude anyone in the world from interfering with that right apart from someone, if there is someone with a better claim to the right in question. That is why property is so powerful, as it implicitly involves a claim that has consequences for just about everyone else in the world. Unfortunately, it's more complicated. In this jurisdiction, there are in fact two types of property right, known as number 1 legal and number 2 equitable interest. The former were the traditional rights of property recognized by the common law, whereas the latter were rights known only to the Court of Chancery. Despite the fact that they both represent a sense of ownership over an asset, legal interest and equitable interest are quite different from one another. A legal property interest conforms to the traditional notion of property. It is a right that binds the world. Legal interest represents an ownership that can be enforced by land. An owner who has legal interest over an asset is able to take legal action in the event that another party tries to overstep his right of ownership. Equitable interest, on the other hand, is where the said party will have a financial interest in the asset in question. An equitable interest holder will be able to enjoy the assets without holding the actual legal title to the asset. The concept of state has enabled English law to develop a complex and flexible means of land ownership. As it is the state rather than the land which is owned, it is often stated that it is only the crown, from whom historically every estate is ultimately derived, that actually owns land under English law. And although there has been sheer skepticism surrounding this argument, no one can deny that the state is the most important interest in land under this system. For the state is an open texted property right that gives its owner possession of the land and the ability to use it in innumerable ways. In contrast to lesser forms of property interest in land, such as easements, which is a right of way exercised by one landowner over that of the neighbor. Restrictive covenants, a private right one landowner has to restrict what happens to the neighbor's lands, and mortgages, whereby someone is granted an interest over land as a security for a debt they are owed, which gives the owner of the interest a non-possessory and much more limited single-use right over the land to which they are attached. It is possible for a lesser estate to be carved out of a greater estate. For example, a person holding an estate in the fee simple of the land can grant a life interest out of his estate to another person. The holder of the life interest will then be entitled to enjoy immediate possession and the use of land for the period of his life, at which point holder of the fee simple will be entitled to enjoy his full unencumbered rights over the land again. Thus, a number of people may enjoy different rights in the same piece of land at the same time, and different people may be regarded as owners of the same piece of land at the same time because the nature of the ownership varies. As between themselves, the right of such simultaneous owners will depend upon who has a better right of immediate possession of the land, and their relationship inter se will be regarded by the incidence of their various rights of ownership. The two most important estates in land today are the fee simple absolute in possession and the term of years absolute. That, as the only leasehold estate, is more commonly referred to simply as lease, letting, tenancy, which is limited and lasts for a fixed period of time. Both estates are limited under Section 1, Subsection 1 of the LPA as the only two estates capable of existing at law, although they can, if the necessary formalities in the creation or transfer have not been complied with, also exist in equity. There are in fact two further freehold estates, namely life estate and the fee tail. These can only exist in equity, that is, behind a trust. Although property interest in land can be acquired via the taking of possession, the vast majority of legal and equitable interest in land are acquired derivatively. This occurs either through the transfer of an existing trust, e.g. when a fee simple owner, leaseholder, mortgagee, etc. transfers the interest to another, or via the grant of subsidiary interest carved from an existing one. That is, when a fee simple owner grants someone a lease, easement, restrictive covenant, or a lessee, that is, an existing leaseholder grants a sublease. Derivative acquisition usually occurs deliberately by means of either a gift or a bargain, in which case it is both reasonable and prudent for the law to require the completion of certain requirements known as formalities, which provide evidence of what was intended, concentrate the minds of the parties involved, and, as the jurist Lon Fuller once noted, channel people down to their certain legal prescribed rules. All contracts in land are governed by the following simple and sensible requirement, that is, under Section 2 of the Law of Property Miscellaneous Provisions Act 1989, a contract to transfer a legal or equitable interest in land must be in writing, containing all the terms and signed by both the parties. Such a contract is known as an estate contract, which is an equitable interest capable of binding the land. Before we wrap up, there are 5 formal requirements that need to be learned and understood, as they are relevant to every aspect of land law. These requirements are slightly more complicated as they differ depending upon whether the interest being conveyed is either legal or equitable. Let's take a look at the first requirement. Under Section 52 LPA 1925, the creation or conveyance of a legal interest in land must be by a deed. Under Section 53, subsection 1A LPA 1925, the creation or disposal of an equitable interest in land must be by signed writing. Number 3. It must also be noted that there are a number of exceptions to these requirements, including short legal leases of no more than 3 years, which provide the rent is at the set market rate and no premium charged at the outset can be created. Only under Section 54 LPA 1925. Let's take a look at the fourth requirement. Under Section 53, subsection 1B LPA 1925, there must be signed written evidence that an express trust of land was declared. The last one is under Section 53, subsection 1C LPA 1925, which says that any subsequent conveyance of an existing equitable interest, whether in land or anything else, must, like the creation or disposal of equitable interest in land, must be by signed writing. Thank you for watching.